serious, sir.
Okay. And I read that motion, and I knew that we were going to leave it set for hearing today since we had this hearing already set today. I've considered what you've written in the motion, and I'm not going to grant that motion. I'm not going to switch to a different judge at this point in time. The case has been pending for over a year, and I'm familiar with the process, the procedure. I've made the pretrial rulings. I've made some evidentiary rulings, and I'm not going to change to a different judge at this point in time. Okay, so I'm not going to grant that motion.
Why is that, sir?
Well, for the reasons that I just indicated. I don't think there's a basis to change to a different judge. I don't have any conflict of interest in any fashion, and I'm the one who's most familiar with the file and have dealt with all of the rulings up to this point in time.
That's why the 14th Amendment says that I have the right to a detached and neutral judge. Like you just said just now, that you are attached to my case. So if you attack that, means that it's prejudice, and so it's prejudice going to be prejudice when I have my bench trial, when I have my trial. So if you said it, that means you acknowledge that the 14th Amendment do count for me, and that's what it says, that you should recuse yourself from my trial.
Okay. Well, I'm not going to argue with you about it, but basically what that means is that it needs to be a judge who's neutral, who doesn't have any personal interest in the case or personal knowledge about the case. I have no personal interest in the case or personal knowledge. The only knowledge I have comes from hearings that we've held and pleadings that have been filed. I am a neutral person. I don't have a bias or prejudice in any way, and I'm not going to change judge. I'm not going to recuse myself, okay?
Okay.